I didn't mean to shoot
You
him.
don't know the answer.
Objection, Your Honor.
Out of order.
Hi, my name is Lucy Lang.
Lucy Lang is a former prosecutor for the Manhattan DA's office and current executive director of the Institute for Innovation in Prosecution.
Today, I'll be breaking down clips from movies and film about the courtroom. Pleading the Fifth, The Good Wife. Roll clip.
Did you and Mr. Kimball travel to Washington, D.C.?
I refuse to answer on the grounds that it may incriminate me.
You're pleading the Fifth?
The Fifth Amendment says that no one can be forced to say something against their own self-interest.
Are you sure that's what you want to do?
Neither lawyers nor judges can compel people to violate that right.
Yes.
Miss, I want to make sure I understand what you're saying.
The judge is out of line and continuing to question this witness.
Your
the
Honor,
leak
it is
of the-
not your place to ask my witness.
After she invokes the Fifth, and the lawyer is right to oppose the judge.
You are piercing the Fifth Amendment right.
Shut
I
up.
don't know what I would do if a judge told me to shut up.
No, sir.
Especially when I was legally in the right.
Excuse me?
I will not shut up.
Objections. How to get away with murder.
Explain why your eviction suit against Miss Morelli was dropped despite her inability to pay rent.
Cheating?
Is it because her lost rent money was nothing compared to the millions you made once Miss Stanley was out of your way? Answer the question, Senator.
I feel for her. She's making a strong point.
If you do not have the time to answer for who bore the real cost of your development.
Objection.
The judge has to rule on the objections, and she should know to stop talking when she hears an objection and wait for the judge to rule.
The thousands who were displaced in the name of lining your pockets.
Cheating?
Continuing after a judge has asked you to stop is very bad practice.
That is enough.
Please, Your Honor.
Objections. Suits.
You'd lie through your teeth about it anyway, wouldn't you?
Objection.
Mr. Evans, isn't it true that you're a
Objection. It's rule of trial practice 101 that when a lawyer objects, the other lawyer waits and lets the judge rule on the objection.
I just caught you in a lie.
Objection, Your Honor.
Mr. Evans, my next move is going to be
Objections are being raised repeatedly, and the judge doesn't rule on it at all.
Jenny Griffith to the stand, and she's going to testify that you lied to her for years.
The
Objection.
most common objections are hearsay objections.
Badgering.
You rarely hear a badgering the witness objection.
She's also going to say that you were jealous of his mind.
Your Honor.
Let me rephrase.
Instead of ruling on the record, the judge gives her a kind of hand gesture. The judge has to rule on the objection, otherwise there's a record that there's been an objection and no ruling.
Objection. Objection. Objection.
That's what the judge is supposed to do.
Mr. Spector is within his rights.
In the presence of royalty. Continuance. Liar, liar.
How are we doing this morning, Counsel?
Your Honor, I would like a continuance.
A continuance is just an adjournment, so asking for a delay by a day or more.
This case has already been delayed.
I realize that, Your Honor, but I would really like a continuance.
He's asking for the continuance because there's something impeding him from the ability to do his job.
I'll have to hear good cause, Counsel.
It's pretty accurate, actually, that he'd be asked to show good cause.
I can't lie.
But he shouldn't be lying in furtherance of his job, so he shouldn't get the continuance, which he doesn't.
Motion for continuance denied.
There is a lot more gavel banging in TV and film than there is in real life.
Order. Order.
In fact, I can't say I've ever had a judge bang his gavel at me. Defendant testifying. Law and order.
So whoever actually pulled the trigger would be the true slave to Allah and should be honored. Is that correct?
You're just like Murdoch. You're both enemies to Islam.
Defendants only testify on their own behalf in the minority of cases, although they absolutely have the right to.
You keep denying it. Is that because you're scared to accept those consequences?
The prosecutor here is cross-examining the defendant, and it's fairly true to life to how it would happen.
She has killed her unborn child.
Where there is an outburst on the stand from a defendant or anyone else,
She poisons women.
in all likelihood, the judge would intervene and tell the witness to manage their temper
And serves liquor in her home.
and probably strike the outburst from the record. For a classic witness outburst, let's look at Legally Blonde.
You, however, had time to hide the gun, didn't you, Chutney? After you shot your father. I didn't mean to shoot him. I thought it was you walking through the door.
Boom. Excellent cross-examination by Miss Woods.
Oh, my God.
She's asking leading questions.
Didn't you, Chutney?
Although her questions are appropriately leading,
Wouldn't you have heard the gunshot? And if, in fact, you had heard the gunshot...
they're compound. She has a lot of questions in one question.
You, however, had time to hide the gun, didn't you, Chutney? After you shot your father.
If I were the prosecutor, I would have objected to those compound questions.
Wouldn't somebody who's had safe...
Right here, she's talking directly to the jury, and that is not allowed.
You, however, had time to hide the gun.
She actually manages to break the witness.
I didn't mean to shoot him.
I've never seen that happen. The classic witness outburst. A few good men.
Colonel Jessup, did you order the code red?
You don't have to answer that question.
I'll answer the question. You want answers?
I think I'm entitled to.
You want answers?
I want the truth!
You can't handle the truth!
The rules in court-martial proceedings are different from the rules in a standard criminal courtroom, but it's unusual for a judge to allow an exchange between a lawyer and a witness to escalate to this level.
I don't give a damn!
If a judge rules that a witness doesn't have to answer a question...
You don't have to answer that question.
The witness shouldn't answer the question.
I'll answer the question.
But I can't argue with this. It's one of the great courtroom scenes of all time.
Did you order the code red?
You're goddamn right I did!
Protesting the verdict, the practice.
We find the defendant, Edward Wicks, not guilty.
What? You call that service?
Miss Gamble?
What are you, moron?
It's hard for any lawyer to lose a case.
That's it!
But this is above and beyond.
What, do you like the color of Mr. Donald's tie?
Miss Gamble!
She should not have reacted that way in front of the jury. Save it for when you get back to your office.
Bunch of unemployed, brain-dead idiots!
In addition to possibly being held in contempt, she could face ethical sanctions from the bar or potentially lose her job.
I don't care, Judge, that's it!
Calendar call. Roman J. Israel Esquire.
What do you have on number 32? Langston Bailey.
This is a very realistic scene of a routine calendar call when a judge has a lot of cases on that are all in a different posture. The prosecutor is there with a banker's box full of case files, which is very common, and she's going to be reading from the materials with respect to each one of those cases.
5 years. That's as low as the people will go.
His name is Langston. He's a high school junior in good standing.
Many defense lawyers would use the kind of mitigating circumstances that Mr. Israel sets out in trying to persuade a prosecutor to make a lower offer.
He has one prior minor offense. Each one of us is greater than the worst thing we've ever done.
I've never heard music in the background when they do it, but otherwise it's very true to life.
Deep vows.
Hollywood loves to take a moral stance in a situation like this, and so do defense lawyers.
Why don't we just get it over with and shoot him?
That's the offer.
It's common for lawyers to negotiate a disposition during downtime in court in situations like that.
Talk to your client.
And the only uncommon thing...
My conviction rate's 100%.
...is the prosecutor referring to her conviction rate, which is just tacky.
It's a fact.
Approaching the bench, Philadelphia.
Did you approach the bench, Mr. Miller?
A lawyer cannot approach the bench ex parte, which means without the other lawyer.
Everybody in this courtroom is thinking about sexual orientation.
This is a great film, but this part is just not realistic.
Explain this to me like I'm a 2-year-old.
The point of approaching the bench is so that the rest of the courtroom doesn't hear you and you're speaking directly to the judge.
Let's talk about what this case is really all about.
So this is inaccurate, first, that the other lawyer isn't there, and second, that everyone in the courtroom can hear him.
Our loathing, our fear.
Again, with the poetic music. Some lawyers might hear it in their head when they're talking, but it's never happened to me. Expert witness, my cousin Vinny.
This witness is an expert in the field of automobiles and is being called to rebut the testimony of George Wilbur.
An expert witness, as compared to a fact witness,
In what way are you qualified?
is a witness who is permitted, based on their expertise, to testify about their opinion, rather than things that are simply facts.
I'd like to voir dire this witness as to the extent of her expertise.
To voir dire an expert witness about their qualification to be certified as an expert, a lawyer would ask them questions about their background.
What would the correct ignition timing be on a 1955 Bel Air Chevrolet?
They wouldn't pose a hypothetical like the lawyer does here.
With a 327 cubic inch engine.
To approach the witness stand, a lawyer has to ask the judge's permission first.
It's a bullshit question.
And it has to be for a good reason, like to show them a piece of evidence or have them point to something.
Does that mean that you can't answer it?
This prosecutor is getting a bit out of line. He's getting in her face.
Nobody could answer that question.
He's speaking aggressively towards her.
You don't know the answer.
And he asked her a hypothetical question.
327 didn't come out till 62, and it wasn't offered in the Bel Air with a 4-barrel carb till 64.
Instead of a question about her expertise. That's inappropriate.
Well, she's acceptable.
Courtroom demonstration, To Kill a Mockingbird.
Tom, will you catch this, please?
You can't use the body of someone who is not on the stand as a demonstration in court.
This time, will you please catch it with your left hand? I can't use my left hand at all.
That's not how the lawyer would make the point that the defendant can't use his left hand.
I got it caught in a cotton gin when I was 12 years old.
He would have had to call the defendant to the stand to testify about it.
Good Lord.
Or call a doctor or someone else who had firsthand experience about the defendant's disability.
All my muscles were toe loose.
When a witness is on the stand, you are only supposed to be questioning that witness, not the defendant or anyone else in the courtroom.
I must be losing my memory.
Atticus Finch is a hero amongst American lawyers, but he just doesn't get it quite right this time.
Sure.
Hostile witness, The Dark Knight.
Someone must have stepped up to run the so-called family. Could you identify him for us, please?
It was me.
When your own witness unexpectedly contradicts your case,
It was me.
then you can ask for permission to treat them as hostile.
Permission to treat the witness as hostile.
This is a pretty accurate depiction of a hostile witness.
Hostile? I see you hostile.
Up until when he pulls the gun and that the lawyer punches him. Courthouses have metal detectors. You can't bring guns into the courtroom unless they're evidence. Violent witness, primal fear.
He put you in front of a camera, he made you take off your clothes, and you don't think that that's another side?
No.
Do you know what I would do if someone did that to me? I would kill
The
him.
moment she's making it about herself, I would have objected.
I wouldn't hesitate.
Lawyers aren't allowed to talk about themselves while they're cross-examining a witness.
I would stab him 78 times with a butcher knife.
I would have objected right there.
I would chop off his fingers.
The judge would have interrupted her as soon as she started to hypothesize about what she would do.
I would slash his throat open.
A judge would ask the court officers to intervene as soon as it looked like things were getting violent.
I swear to God.
This is a terrifying movie, and Laura Linney's character is way out of line.
But that's me.
Sometimes lawyers do try to agitate a witness in order to get a reaction from them.
Further questions, Your Honor.
Where the hell do you think you're going?
Which seems to be what she's trying to do here, and actually she does.
You lady, come here!
It's rare for a witness or a defendant to get violent, but it does happen, and that's why there are armed court officers in every courtroom for criminal trials.
No! No! Don't you? No!
Character witness, Big Daddy.
Koufax is a good egg. He was nice to that kid. Mr. Koufax is a really cool guy, but he fights like a girl.
Were you drunk, Mr. Hurley?
Under the rules of evidence, a character witness can only testify about something that's at issue.
Wish my dad was as cool as him.
So where the issue is whether or not he's a good dad, they could testify about his reputation as a good dad in the community, but they can't testify in general about whether he's cool.
Mr. Koufax is a really cool guy.
And they can't go off topic.
You see, my dad was a military man. I'd rather live out on the streets than under his freaky-ass rules.
And also, the plaintiff should definitely not be bribing the witness with McDonald's.
If O.J. can get away with murder, why can't Sonny have his kid?
Jury selection, the devil's advocate.
Let's get rid of number 4, 6, and I'd say lose number 12, except the prosecutor's gonna up and do it for us.
Both sides have a set number of peremptory challenges they can use to strike potential jurors.
Number 6? You're kidding, right? She's my first choice.
They can both agree to strike anyone, and that doesn't count against them. And no one can strike a juror on the basis of a protected category like race, gender, ethnicity, or sexual orientation. But beyond that, it's no holds barred.
She wants on this jury. Somebody hurt her and she wants revenge.
Lawyers definitely try to psychoanalyze potential jurors based on what they're wearing and the way they comport themselves. We're often pretty wrong.
How the hell do you know that?
In my experience, most of the time, people are trying to get out of jury duty, so I'm not sure how he thinks he can tell that she wants to be on the jury.
I don't know.
People have all kinds of funny superstitions about who they won't let on a jury. None of this is based on science. It's all basically guesswork. And the bottom line is that you want a jury who can be fair.
All right, here's the deal. I lose with your jury, you do the explaining.
Here's another example of jury selection. The Rainmaker.
Did you, Mr. Porter, or did you not have a phone conversation a few days ago with Mr. Rudy Baylor?
Hell no.
I thought you were going to give me an honest answer.
This is an example of voir dire, the lawyers questioning the jury about their ability to serve.
Don't call me a liar.
Oh, you're a liar, all right. Son of a
There's an awful lot of jumping over the rail that seems to happen in film and TV. I've never seen it happen in real life. When something happens that can taint the whole jury pool, often a lawyer will make an application to have the whole pool dismissed and a new pool brought in.
I move to dismiss the entire panel, Your Honor.
Here, the judge probably would have granted that application.
Denied.
Film and TV love to show jury selection.
It's been tainted.
Frankly, most lawyers hate it.
You left it open.
The judge saying out of order. from Justice for All.
Something really wrong is going on. Mr. Kirkland, you are out of order!
A judge would typically call for order in the court in a situation like that.
You're out of order!
But generally much earlier.
The whole trial is out of order!
The kind of language that he uses is totally inappropriate. And then he turns on his own client.
Slide.
The lawyer is undermining his ethical obligations.
Sorry, Your Honor.
Hollywood loves to show emotional outbursts from lawyers.
You son of a...
Those are pretty uncommon. We do our best to control them. We're going to be seeing a lot of them today, though.
I just completed my opening statement.
Removing the witness from Daredevil.
I know what I did. I know who I am. And any scumbag, any lowlife, any maggot piece of shit that I put down.
A judge would reprimand any lawyer or witness who used bad language in the courtroom.
I did it because I liked it.
Most lawyers would work closely with the defendant before he took the stand in order to guard against those kind of emotional outbursts.
The big bad punisher.
Remove the witness.
Court officers are trained to respond to a judge's orders immediately.
You want it? I'll give it to you.
Here, the court officers do take him out as soon as the judge instructs them to.
Remove the witness.
Most judges would respond more quickly to have that defendant removed from the courtroom.
You gonna send me to a nut house?
That kind of scene is fairly uncommon.
Well, that ain't happening.
Settlement, a civil action.
You come to me?
The jury's been impaneled and opening statements are about to begin, but the lawyer sees the effect that seeing the plaintiff is having on one of the jurors, and so that leads him to negotiate. It's very common that plea negotiations would continue through a trial like this. Plea negotiations have to happen outside the awareness of the jury. So if the jury were in the box like this and the parties were trying to negotiate, Post-its is exactly how they would do it.
Jan Schlickman for Paul Carney.
Kevin Conway for Mr. Carney, Your Honor.
I'd start sweating too if I saw a juror respond like this. It is far more likely for both criminal and civil cases to be resolved with a plea or settlement disposition.
The parties involved have agreed to a settlement.
And going through to the conclusion of a trial. Courtroom attire, The Simpsons.
I rest my case.
The phrase, I rest my case, is a commonly used one.
Mr. Hutz, do you know you're not wearing any pants?
We usually wear pants to work. The formality of courtroom attire has decreased in recent years.
Right.
But not quite to that level.
That's why you're the judge and I'm the law-talking guy.
The lawyer.
Witness stripping, Franklin and Bash.
And how exactly did you book the mattress master's ad?
My agent.
Objection, Your Honor. She's disrobing?
To my knowledge, there's nothing in the rules of evidence that says a witness can't take their clothes off.
The client wanted a model who could demand attention.
Your Honor.
But it's against all rules of courtroom decorum.
Ms. Spencer.
Lawyers advise witnesses to behave respectfully towards the court, including dressing appropriately for court.
Please refrain from taking off your blouse.
And not undressing in court.
Don't listen.
Of all of the unrealistic things in this scene,
Excuse me.
The most unrealistic is when the lawyer tells the witness to ignore that.
Did you just tell the witness to disregard my order?
That should never happen.
Justice is blind.
This is so dumb.
But justice is also naked.
Let's focus on what she had to say.
I didn't get it.
There's a request for readback again.
I was distracted.
But this stenographer really dropped the ball on her job.
If we were all distracted by Miss Spencer in court, what about the people operating heavy machinery on Sunset Boulevard?
This is made for TV alone. Film and TV love this, where something happens in the courtroom and then the lawyer uses it to prove their case.
Distracted.
That's not a real thing. Only things that are in evidence get to be used to further an argument.
Like that ever scares us.
Applause in the gallery. Changeling.
Walter Collins was brutally murdered. Is that correct, Captain?
When a lawyer is questioning about something as dramatic as that, everyone in the courtroom can feel the tenseness of the situation.
Yes, it is.
The lawyers, the jury, the audience, everyone.
No further questions.
In the modern day, applause is not allowed in the courtroom. But before we had courtroom scenes on television and film, people would go to court to watch proceedings as part of their entertainment. And during that time, sometimes there would be applause in the courtroom.
Just like that.
Contempt of court, serial mom.
One beer with lunch is hardly drinking.
Did you see that? She just said F you to me.
The lawyer's antagonizing the witness, so if the judge saw that, she would have been reprimanded.
Let the record show I am merely standing here.
Again, it's all about the record. So if the stenographer didn't hear it, it's like it didn't happen.
Are you insane?
No, I'm not, you mother.
In Hollywood, courtroom scenes are so emotional
Zinko, I find you guilty of contempt.
that judges are threatening to hold people in contempt all the time.
You lousy pig!
In reality, I think I've probably only seen it happen once or twice. Midnight deadline, night court.
Unfortunately, word got out that anyone not arraigned before midnight was set free.
Wow, look at her hair.
Oh, we were so close.
Oh, well, that's it. We're finished.
No, we're not. Hold on.
Night court arraignments really happen in New York City and all over the country.
Count one. The other side declared complaint states without prejudice.
They tend to be very busy and fast-paced, but not this fast-paced.
386 and above the judicial district in New York.
Arraignment is the first time that someone who's charged with a crime hears the charges read formally against them.
New York State, New York, crime of violation 231.
Sometimes it happens in night court.
Drive a vehicle. Count two.
When someone gets arraigned, their lawyer says, waive the reading, not the rights. And what happened in that case, the defendant didn't want to waive the reading, so that's why he was forced to read them all aloud.
Alcohol, drive a vehicle. The end. Court
Defendant representing himself, law-abiding citizen.
And you've waived your right to counsel, correct?
Yes, sir.
You sure you want to do that?
Defendant has an absolute right to represent himself in court. Usually, a defendant is assigned backup counsel who actually has legal training.
I find it highly prejudicial to keep me detained without bail.
When a defendant is representing himself, he's granted more leeway than a lawyer is in terms of editorializing about what he thinks is happening in the courtroom.
The prosecution has not presented one single piece of evidence against me.
He's advocating for himself, and he's entitled to do that.
It's a slippery slope, Your Honor.
It's not inappropriate, and I think it's fairly realistic.
I am actually inclined to agree with you, Mr. Shelton.
Thank you.
Indicting a dog from Perry Mason.
Present or not, a man is still responsible for what his dog does. Not criminally, Mr. Rice. That depends upon a number of things. Perhaps the proper criminal procedure would have been an indictment of the dog. Counsel was joking, of course. Not at all.
Here, the argument is about whether the person can be charged for something that an animal did.
A variety of animals have been accused, legally indicted, and tried in the past.
In the modern day, animals can't be indicted and charged.
The last being a cow in 1740.
However, animals can be considered dangerous instruments for the purposes of a person committing an assault.
Since this is the 20th and not the 15th century, I'm going to rule that the complaint is sufficient.
Setting bail. 50 Shades Freed.
Does your client deny forcing entry into this penthouse?
He does not, Your Honor. However, my client merely wanted to confront the parties responsible for destroying his career.
I think he wanted to do more than confront them, Counselor. However, given his clean record, the court will grant bail.
The basic options when a judge is making a decision about bail are releasing someone on their own recognizance, which means counting on them to return on their own free will. Setting bail, which means determining an amount of collateral that they will give over, and that is likely to ensure that they return. And remanding them, which means that no amount of money or collateral will allow them to be released while the charges are pending.
Set at $500,000.
$500,000 bail is not unheard of, depending on the gravity of the charges, the defendant's criminal history, their community ties, and their access.
Your Honor.
Next case.
Very often it has the result of meaning that someone can't make the bail and therefore stays in custody. Readback, intolerable cruelty.
Does Elzbieta want some bones?
Where were we?
Do you want some bones? Does Elzbieta want some bones?
This is called readback, where a lawyer doesn't hear or loses track of what the response has been. They can ask the stenographer to read back from the transcription.
Has anyone any bones?
Readback can happen during the trial for a lawyer, or a jury can ask for readback during their deliberations if there's something they don't remember.
Hard, crunchy bones.
Right. What's not accurate is that a dog would be in the courtroom on the stand with a witness unless it was a therapy dog. Surprise witness, the good fight.
Thank you for testifying on such short notice, Miss Lockhart.
I didn't have much choice. I was subpoenaed.
Your Honor, again, this is prosecution by ambush. We are not prepared for this surprise witness.
That's just how that would happen. The prosecution has to disclose their witnesses in advance of trial to permit the defense to appropriately prepare.
Yes, and as I said, you will have time if you need it. Please continue.
When something changes and a new witness comes to light, the prosecutor might be permitted to call that witness, but as the judge promises here, the defense would then be granted plenty of time to be able to prepare to cross-examine that new witness.
Yes, and quite well.
Miranda writes, Medea goes to jail.
Apparently, Your Honor, our officers forgot to Mirandize her.
I was waiting for Miranda to come in and nobody came in there. I was waiting for her. That's right, ain't nobody Miranda me. Miranda wasn't even in the room.
No.
Excuse me?
Miranda is the case that holds that officers have to read a defendant their rights before questioning them.
This is ridiculous.
What they're referring to here is that Medea made a statement to police officers, and she did it without having been first read her Miranda warnings.
You forgot to Mirandize her?
That old woman got the strength of any man.
When that happens, the statement that's made gets suppressed as evidence, which means it can't be used against the defendant.
I've got to let you go.
But it's not the case that the defendant then just gets let go.
You gotta let me go.
Conference in the judge's chambers, the verdict.
All I want on this trial was a fair shake. Okay? Push me into court 5 days early. I lose my star witness, and I can't get a continuance, and I don't care. I'm going up there, I'm going to try it, I'm going to let the jury decide.
It's a TV and film trope that judges and lawyers are combative with each other.
They told me about you.
In general, we're all professionals, and we try to maintain standards of professionalism and decorum.
So you're a hard ass, you're a defendant's judge? No, I don't care.
It seems like bad strategy to be leveling personal accusations at the judge while he has a case pending in front of him.
I said to hell with it, to hell with it!
Dismissing a case, Miracle on 34th Street.
If the government of the United States can issue its currency bearing a declaration of trust in God, then the state of New York can accept and acknowledge that Santa Claus does exist, and he exists in the person of Kris Kringle.
Don't tell my kids, but I don't think the existence of Santa Claus would stand up in court.
Case dismissed.
Again with the gavel. This is in New York, and I haven't seen a judge in this courthouse do that. Summation, or closing statement, the night of.
What I normally do is plea my clients out, because 95% of the time they did what they were charged with. It's clear to me just looking at them, so I tell them, don't be stupid, take the deal.
Summations can only be about the facts that are in evidence.
It's what we think.
Anything about the lawyer's personal contact with the defendant, with the witnesses, or their experience in general is totally outside the bounds of appropriate summation.
The first time I saw Naz, he was sitting alone in a holding cell at the 21st precinct.
Objection. Also not in evidence.
I didn't see what I see in my other clients.
John Turturro, this is not about you.
What we don't have proof of is who committed the crime he's been charged with.
That last part of the summation where he's talking about the facts that are in evidence.
It's circumstance and speculation.
That is the purpose of summation.
You hear that term a lot. What does it really mean? Huh?
For another example of summation, let's watch A Time to Kill.
I'm going to ask you all to close your eyes. This is a story about a little girl. I want you to picture this little girl. Two men jump out and grab her. They drag her into a nearby field, raping her.
This is really the appropriate time for a lawyer to get theatrical on summation, and that's exactly what he does here.
I want you to picture that little girl.
He lays out his view of the facts of the case and then makes a powerful argument about bias.
Now imagine she's white.
This is exactly the appropriate use of a summation, although it's awfully hard to watch.
The defense rests, Your Honor.
Conclusion.
At the end of the day, I don't expect actors and directors to get every detail right. I understand that writers like to make courtroom scenes seem more dramatic than they really are, but sometimes they get it wrong, and they're pretty fun to watch.